Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. The criminal appeal is taken up for disposal on remand from the Supreme Court by order dated 29/3/2007 in Criminal Appeals of 2003, whereby the Supreme Court observed as follows: para. Without going into the merit of the case and in view of the fact that now new materials are available on record, we think it fit and proper to set aside the judgment of the High Court and remit the matter back to the High Court for consideration of the matter afresh in the light of the evidences adduced on behalf of the appellant. Stop. Para. The criminal appeal is filed against the judgment on the file of Additional Sessions Judge Chennai against the judgment dated on the file of the Metropolitan Magistrate Georgetown Chennai. Stop. Para. The appellant as complainant has filed a private complaint stating that the respondent accused has borrowed money from him, and after some time the respondent accused issued two checks, both drawn on Syndicate Bank Chennai. Stop. The first check represented the principal amount and the second check represented the interest. Stop. The appellant complainant deposited the said checks in the bank, but both the checks were dishonored by the bank on 2/4/1998, stating insufficient funds. Stop. The appellant complainant issued legal notice through his lawyer and he received reply notice, and then the appellant issued rejoinder and filed the complaint in accordance with law under section 138 of the Negotiable Instruments Act. Stop. Para. The trial court, after taking cognizance of the offence under section 138 of the NI Act, issued summons to the respondent accused, and after questioning the accused, examining prosecution witnesses and marking exhibits, by judgment convicted the respondent accused for the offence under section 138 of the NI Act and sentenced him to undergo simple imprisonment for 1 year and to pay a fine of rupees 13 lakh in default to undergo simple imprisonment for 1 month, and out of the fine amount the trial court directed the complainant to pay rupees 14 lakh as compensation. Stop. Para. Against the said judgment of the trial court, the respondent accused preferred appeal in criminal appeal, and the first appellate court allowed the appeal filed by the respondent accused and set aside the conviction and sentence passed by the trial court and acquitted the respondent accused of the charge under section 138 of the NI Act. Stop. Para. Against the said judgment of the first appellate court, the appellant complainant has filed the present appeal before this court, and this court by judgment allowed the appeal by reducing the sentence of simple imprisonment to 3 months and also reduced the amount of compensation to rupees 6 lakh and deleted the sentence of fine. Stop. Para. Against the said judgment dated 13/12/2002 passed by this court, the parties preferred appeals before the Supreme Court, and the Supreme Court by judgment dated 29/3/2007 remanded the case as indicated above, and the appeal is now heard afresh. Stop. On remand from the Supreme Court, now this court has to decide as to whether the respondent accused is guilty of the offence under section 138 of the NI Act. Stop. Para. After hearing the arguments of both sides, the only dispute is to be decided is as to whether on the date of issuance of the checks in question, there is any subsisting liability on the part of the respondent accused. Stop. Para. Learned counsel for the appellant complainant would contend that the handing over of the checks in question has been admitted by the respondent accused, and hence the presumption of facts under sections 118 and 139 of the NI Act and sections 3 and 4 of the Indian Evidence Act be drawn from the existence of certain facts, and the presumption drawn in respect of one fact may be used for the purpose of drawing presumption under another fact. Stop. The first appellate court has not considered this aspect in proper perspective. Stop. Para. Learned counsel for the appellant complainant further contended that the respondent accused borrowed rupees 6 lakh and executed a promissory note, and the respondent accused paid only rupees 10 and made an endorsement. Stop. Since he was not in a position to discharge the loan amount due on promissory note, the respondent accused earlier issued 2 checks for rupees 5,80,000 by calculating interest. Stop.